Hi, this is Bobby Hargis. We are continuing our discussion of impeachment in Louisiana state courts. My goal with this lecture is to continue my discussion of what impeachment is, and we will have problems in this lecture to illustrate the various methods of impeachment. What you see on the screen is the cover page of an article that I wrote for the Louisiana Bar Journal. The article appeared in the December 2018, January 2019 edition of the Bar Journal. I wrote this article to summarize the 8 means of impeachment allowed by the Louisiana Code of Evidence. What are those 8 means? Well, if you look here on the second page, left-hand column, a witness may be impeached with evidence of the witness's bias, the fact that the witness may have an interest in the outcome because of corruption. The witness may have a defective capacity, for example, a vision problem or hearing problem that may affect the accuracy of the witness's testimony. A witness may be impeached by a prior inconsistent statement. When there's a prior inconsistent statement used to impeach, the witness must have made a prior statement prior to the trial. Another way that a witness may be impeached is contradiction. Contradiction means basically you bring in other witnesses or other evidence that is at odds with what the witness has testified to. A witness may also be impeached by another witness. When another witness comes in and after the appropriate foundation has been laid under 608, testifies that the prior witness has a bad reputation for truthfulness. And finally, a witness may be impeached by conviction of a crime. Impeachment basically deals with suggesting to the finder of fact that the witness's testimony is not truthful or entirely truthful, is not accurate or entirely accurate. Let's talk for a moment about what bias is. Bias is something that suggests that there is a relationship that the witness has with one of the parties that might suggest that the witness is not telling the truth. For example, a mother who testifies at the trial where her son is charged with a burglary. The finder of fact will want to know that that person is the mother of the defendant because she may consciously or unconsciously lie. And that's something that the jury should know about. Another method is bias, not bias, interest. Interest is closely related to bias. If a witness may be affected by the outcome of the lawsuit, the jury should know about that. For example, in a civil matter, if the plaintiff won a breach of contract action filed against the defendant, a witness with personal knowledge of the contract could be questioned about the fact that the verdict would have a positive effect on her business. That would be something that the jury would want to know because that person might not testify truthfully. Corruption is a very specific type of impeachment. It's based on the State versus Capel case where the Louisiana Supreme Court allowed testimony about the prosecution witnesses' disposition to make false charges against others. This is a very, very narrow fact pattern, and corruption has been limited basically to facts that are very similar to State versus Capel. Defective capacity is basically anything that would suggest that the witness may not be accurate because of the inability to perceive something through his or her senses. An accident witness, an eyewitness to an accident, may have been on drugs or alcohol prior to the viewing of the accident. That may affect that person's capacity. The person may have limited eyesight, limited vision, or if the person says she smells something and she has some issues with her sense of smell, that could be inquired into as a way to impeach that witness. A prior consistent statement suggests that the witness is mistaken because she made two different statements about the same matter. She made one statement at trial and she made another statement prior to the trial. So keep in mind that when a witness is impeached with a prior inconsistent statement, it is the witness's own prior statement that was made at some time prior to the time that the witness is testifying. Contradiction is another form of intrinsic impeachment. It's basically any other evidence or testimony that is different from what the witness has said. So if the witness says the light was green and another witness says the light was red, that's contradiction. That's contradictory testimony. It means testimony from another source or another person that is at odds with what the witness has testified about. Also under Article 608A, now this is very similar to Article 405. As you know, under the mercy rule, where a defendant in a criminal case can bring in a good reputation witness to testify that the witness has a reputation for doing things that are good, like being nonviolent or doing things that are truthful. Article 608 allows any party, prosecution, defense, plaintiff, or defense, to bring in a bad reputation witness to suggest that the prior witness, any prior witness, this is not restricted to criminal cases, it's not restricted to civil cases. So Article 608A allows a cross-examiner to attack the credibility of a witness by calling a reputation witness who's familiar with the principal witness's credibility. Who's the principal witness? The principal witness is basically any other witness who testifies. So let's say that one party calls a character witness to testify that say witness one. Witness one was, let's say, the plaintiff in a personal injury case. The defense could call a character witness. We'll call that person witness two. The defense in a civil case could call witness two to testify after the appropriate foundation is laid on Article 608A that witness one has a bad reputation for truth telling. Similarly, the plaintiff could call another witness, a character witness. We'll call that person character witness two. That witness is also witness three. Witness three, after the appropriate foundation, could testify that witness two has a bad reputation for truth telling. And it goes on and on. So any party can call a character witness to testify that any earlier witness has a bad reputation for credibility, for truth telling, for telling the truth. That's what 608A is all about. So it's similar to 405, but it's not limited to the criminal context. Similarly, under Article 609, that's an article for civil cases. This is very similar to Federal Rule of Evidence, Rule 609. There's only one rule in the Federal Rules of Evidence that deals with conviction of a crime, and it's 609. But in Louisiana, we have two. We have 609 and 609.1. 609.1 is criminal cases. 609 is for civil cases. So a witness can be impeached based on prior convictions. The suggestion is that the witness is not credible because the witness has violated the law, and the witness should not be believed because the witness disrespected the law. And if the witness testifies, she could disrespect the law by ignoring the oath or affirmation that she earlier took, that she stated that she would tell the truth. It is important to note that prior bad acts, basically any bad act where there is no conviction, cannot be used to impeach. So we have some examples here. A person cheating on an exam or accused of stealing money from her employer, from her church. And if there's no conviction, Article 608 says you cannot ask a witness about it, which is intrinsic impeachment, but you also cannot bring in additional evidence in the form of extrinsic impeachment. So that is the summary of the 8 different ways you can impeach a person in Louisiana state courts.